Good afternoon and a warm welcome. I'm Tom Clark, the editor of Prospect Magazine, and I'm thrilled that so many hundreds of you have signed up for this, the second of our webinars with the wonderful Bingham Centre for the Rule of Law and Jones Day on broad subjects which might be characterised by the title of the late Tom Bingham's book, The Rule of Law. Last time we heard from Lord Jonathan Sumption on the danger, as he sees it, of legal overreach in the COVID age. By contrast, one of our speakers today, a year ago, ruled against an abandonment of lawful process at the heart of British politics. Amid a frenzied politics that increasingly kicks against the very ground rules of the game, today's theme, the independence of the judiciary, acquires a new urgency. We're seeing that in spades in America as well as in Britain, but at least over there the media is used to reporting on the grey zone where politics runs up against the law. In the UK, we're still catching up, but Prospect is making the running, with essays and interviews with judges and lawyers, as well as the regular column by David Allen Green. If you're interested in today's themes, we're confident you'll be interested in our coverage. So we will take the chance, I'm afraid, to email you about a subscription offer with a free copy of the Secret Barrister's book as well. But that is more than enough from me. I'd just like to welcome our Jones Day colleague, Sean Richards, who's going to introduce our splendid speakers.
Thanks very much, Tom, and good afternoon, everyone, and thank you for joining us. Tom says my name is Sean Richards and I lead the Global Disputes team at Jones Day in London. The UK's judiciary is renowned across the world for its impartiality and objectivity. Individuals and businesses from across the globe turn to London, knowing that their cases will be decided on the merits alone without outside influence. These rudimentary values and the rule of law matter today more than almost ever before. Indeed, if you've spent time somewhere where the rule of law is absent or weak, you will appreciate how fundamental it is to one's well-being and sense of security. In the year to March 2020, London's commercial courts heard cases from parties from 72 different countries, with some 55% of litigants coming from outside the UK. According to the SRA, legal services make up as much as 40 billion of the UK's economy, with the UK having the second largest legal services market in the world. These numbers help illustrate London's prominent standing as a centre for international dispute resolution. To speak about the rule of law and judicial independence in practice, we at Jones Day are honoured to be joined by Baroness Hale and Dame Elizabeth Gloster. Baroness Hale's distinguished career has included being the first woman to be appointed to the Law Commission, the first High Court judge appointed from academia as opposed to the bar, the first woman Lord of Appeal in Ordinary, and the first woman justice and subsequently president of the Supreme Court, from which she retired in January of this year. Dame Elizabeth served as a High Court judge before becoming the first woman to be appointed a judge of the Commercial Court. Dame Elizabeth later sat on the Court of Appeal and served as Vice President to the Civil Division of that court. In 2018, she returned to One Essex Court to practice as a full-time commercial arbitrator. She will offer her reflections on today's topic from the perspective of her own career and her current role as Chair of Legal UK, which facilitates collaboration between the legal profession and other city institutions. We'll now hear from Baroness Hale in conversation with BBC journalist and presenter Razia Iqbal. Over to you, Razia.
John, thank you very much. It's an absolute privilege to be here this afternoon. Welcome, everybody. Lady Hale, let's begin with the title of this particular webinar, the safeguarding of London's standing in international dispute resolution. I wonder if you'll outline for us the single reason that businesses and individuals choose English law to govern their transactions and resolve disputes.
Well, they've got, of course, a choice. They can choose English law to govern the dispute, and they can also choose the English jurisdiction to adjudicate on their dispute. They are two different things, and they don't have to choose both. But there is no doubt that they choose them both partly because English law has been long established in the commercial law area for a very, very long time, and partly because they have confidence that their disputes will be heard and decided by independent judges who are not going to be influenced by outside considerations. I always talk about our judges having the 4 in quotients required of top judges. One is intelligence, of course. Another is industry, hardworking. Another is incorruptibility. We take that for granted here, but not everywhere does. And the 4th is independence, which is slightly different from incorruptibility. I could add some more, like integrity and lacking in influence in the individual situation, lacking in bias, and so on. But all of those things ought to be the qualities of a good judge. We do our best. We're not perfect.
Well,
those are the reasons.
Let me get you to make the differentiation between incorruptibility and independence, because it's a very interesting distinction that you're making, and it will feed into some of the things that I want to ask you about our standing internationally as well. So why don't you reflect on that for us?
Well, straightforwardly, incorruptibility means you don't take bribes. And bribes aren't always just in money, they can be in other things as well. Independence means that you make your own mind up. You listen to the arguments, you hear the evidence, and you apply the law to those arguments and evidence without external influences. So they are slightly different things.
Of course, and without outside influences, of course, means in being independent of the politics.
Well, that's one of them, but it's not the only one. I mean, one ought to try and be independent of one's own inclinations. This is easier said than done, obviously. Those of us who were in personal injuries law, for example, not commercial law, always knew that there were judges who were instinctively in favour of claimants, and other judges who were instinctively in favour of defendants, usually insurance companies, and so on. And in family law, there were judges who were in favour of mothers and judges, or mothers and wives, and others who were in favour of fathers and husbands. But we have to try and suppress that, our own individual preferences, and look at the thing objectively and in the round. And I think, to their credit, most people do manage to do that. The greatest thing about my colleagues in the senior judiciary is that they are not too predictable.
I wonder, though, how it's possible to continuously and consistently, probably more, the better word is consistently, find yourself in a place where you do not respond to your own inclinations and your own preferences.
It's very hard. It is very hard. And so one has to be constantly on the lookout for that. But I think most people manage to do it most of the time. As I said, the great Lord Bingham used to say that he always hoped that he would not be predictable in his response to a particularly difficult legal question. And most of the time he was probably right about that. And I would say the same about other justices that I have known in my career. You couldn't tell instantly what way they were going to decide.
We were hearing from Sean earlier this idea that you would be very aware in parts of the world where the rule of law is not paramount or where there is a weakness in the rule of law. It's clearly something that is under pressure in many countries around the world. And when you and your fellow justices made that historic ruling in September 2019 that the Prime Minister of the United Kingdom had acted unlawfully in suspending Parliament, obviously created enormous shockwaves here. But were you surprised by the international reaction in places where people were surprised by the ruling that had been made?
Well, I think I was surprised that there was such international interest in what might be regarded as a little local difficulty in the UK. But there was a huge amount of interest throughout the Anglo-American, the common law world. So the Commonwealth and in North America and so on. There was a lot of interest. And that is because there is a lot of interest in constitutionalism, in the rule of law and the independence of the judiciary. I'm sorry they were surprised. Because after all, it was a unanimous decision of all 11 of us. And so that's quite a lot of serious legal brains who thought the same way on it. But I think the reaction, certainly from the Commonwealth, was very, very favourable because they felt that if we had decided it the other way, that would have given the green light to some of their governments who might be inclined to push the vote out, shall we say, constitutionally, to go ahead, thinking that the judiciary would not be able to stand up to them. So it definitely was encouraging in quite a few places.
And I wonder then, in that context, whether we can talk a little bit about the potential fallout from the internal market bill, which is, I think, about to have its second reading in the House of Lords. By their own admission, the government says that this is a bill, which when it becomes law will be breaking international law, but only in a limited and specific way. In that context, I wonder if you will reflect for us on the reputational damage that breaking international law does to the perception of this country, the reputation of this country, not just now, but going forward when we are formally and no longer inside the European Union, and we will have to make relationships in a completely different way as an independent country.
Well, obviously, I don't want to make any sort of comment on the political pros and cons of doing what that bill does. It's a calculation as to whether the benefits to be gained from doing it outweigh the disadvantages of doing it, of course. That is not something which I'm qualified even to judge. And I also understand that it's only a conditional breaking of international law, in the sense that if there is a proper agreement, well then the fallback in the bill will not be required. And so to that extent, it isn't in itself breaking international law. What it is doing is giving the government the possibility of breaking international law. But having said all that, obviously you are correct to say that our future has always depended upon our making agreements with other countries. Treaties go back a very long time, and countries make treaties because it's in their interest to make treaties with other countries. And we have an enormous number of commercial treaties which we have been parties to and which we try very, very hard to keep. And our being party to those treaties is an important part of UK PLC, our brand in the outside world. And so obviously there is a potential for reputational damage if the UK can conclude a treaty in 1 year and then the next year give itself power unilaterally to break that treaty in however a minor and limited and conditional way. It obviously is going to have potential reputational damage for the whole UK and therefore for the business of UK PLC, as we sometimes refer to it.
I mean, and even beyond the possibilities of commercial reputational damage, I'm thinking much more about our ability diplomatically to be able to criticize other countries who break international law, and what that allows, or what kind of position that puts the United Kingdom in when, say, for example, we want to criticize China for having done something.
I think perhaps you should ask a diplomat that question, or a politician, as to how much more difficult it would make their lives. It is for anybody very hard to keep on a high horse if you yourself have dismounted from it, however temporarily. But sometimes people are prepared to carry on regardless and to understand that that these things happen. After all, we are very hot on keeping to our international obligations under the Human Rights Convention at the moment. And we are very keen that other members of the Council of Europe should do the same. And yet, for a very long time, we did not do anything about the judgment in relation to prisoners voting, the disqualification of all sentenced prisoners from voting, no matter what the circumstances of their imprisonment were. And the UK dragged its feet for a very long time about that. Eventually, they did some very, very small things, and the Council of Europe agreed with them and let them off the hook. So we can't always claim the high ground on everything. Yes.
I wonder, I brought up China because I know that since you retired, you have sat on the Hong Kong Court of Final Appeal as one of the non-permanent judges. And in the context of the independence of the judiciary, which is something that is clearly very important to you, how concerned do you think we should be about the ability of the judiciary in Hong Kong, for instance, to maintain their independence in the context of the new security law, which has been imposed by Beijing?
Well, number one, I have never sat in the Hong Kong Final Court of Appeal. I have been a member of it, a non-permanent judge there,
right.
For about probably 2 years, but I have never, ever sat because I told the Chief Justice that I wouldn't be able to sit until I'd stopped being president of the UK Supreme Court, because I thought I ought to concentrate on the day job, basically. And I was due to sit in February this year, but because of COVID, I didn't. And so I have never sat, and it has not been arranged, at least yet, for me to sit. When that happened, I would have a serious moral question to ask myself. And so I think that most of the UK non-permanent judges are waiting to see how things turn out and how things develop in Hong Kong. An Australian judge has resigned from the court, but he's been replaced by another UK judge. So some people are waiting and seeing. That's all I can say.
So when you say, just to press you a bit, when you say that you would have to ask yourself a moral question about it, and is that because there is a sense already that the judiciary in Hong Kong would not have the ability to be independent in the context of that law in particular?
Well, if one looks at that law, it has the potential to undermine the independence of the judiciary. It may, in practice, not work out that way. So that's why there's a wait and see policy being adopted by most of the non-permanent members. It has the potential to do that, there's no doubt about that. But the Chief Justice of Hong Kong has been seeking assurances from the Chief Executive, which would enable the judiciary to retain its independence. And well, he's doing a great job to the best of his ability, which is, again, why only time will tell.
Let's come back to the United Kingdom. You wrote in a book called Justice Matters, a very slim book published by the Legal Action Group, about the way in which the Coronavirus Act of 2020, in your view, in passing that act, Parliament had surrendered its role over the COVID emergency laws, and that was something that you didn't think was the right thing to have done. I wonder if you will just talk us through what it was that you wanted to highlight when you wrote those 2 pages in that book.
Yes, well, it wasn't only about the Coronavirus Act, it was also about the use which is being made of the Public Health Act. Because most of the restrictions that affect our everyday lives have actually been imposed under the Public Health Act. And so we have a situation in which the regulations which are made lapse or can lapse after 28 days, depending on the nature of the process. But they've usually been replaced within 28 days. So by the time they get before Parliament, I mean, there was an extraordinary day the other week in which there were several sets of regulations coming before the House of Lords for them to express a view on, and they were already obsolete. Now that doesn't seem to be effective parliamentary control. And one could think of ways in which effective parliamentary scrutiny could be adopted. I mean, it would be hard work and it would mean people had to jump very, very quickly. But you could think of ways in which it could be done so that the government was accountable to the Houses of Parliament for these very draconian restrictions on our everyday lives that are being imposed really at very short notice. So and that's the point I was trying to make.
Absolutely understood. And on the point of being more nimble-footed, how do you think that could have happened or can still happen in practical terms?
Well, the trouble is the enabling legislation, the Coronavirus Act, under which some things are done, and the Public Health Act would have to be amended so that the regulations did not have automatic effect without parliamentary scrutiny, or didn't have automatic effect for so long without parliamentary scrutiny. That's the sort of thing that would have to happen. Or Parliament would have to try and convince the government to adopt a different practice, which they could do without amending the legislation if they wanted to. And it's noticeable that there are many members of Parliament, often on the government side, who are increasingly concerned about the way things have been going up till now. They probably wouldn't have been concerned if they were relatively minor interferences with everyday life, but given how severe they are, then that does ratchet up the concern that parliamentarians have about this.
I wonder if I can take you back to the 4th of November in 2016, the day after the 3 High Court judges ruled that the UK government would require the consent of Parliament to give notice of Brexit. I want to ask you about this in the context of the media reaction to that, and in particular 2 headlines in the Daily Mail and the Daily Telegraph. The Daily Mail in particular, the headline was "Enemies of the People" and the 3 photographs of the High Court judges. How would you reflect now on the impact of that in terms of the way in which the public understand the independence of the judiciary? How damaging do you think that was?
Well, number one, I'm afraid it indicated either that the authors of the headline did not understand what the case was all about, or willfully shut their eyes to what the case was all about. Because the case was not about whether we did or did not respect the result of the referendum and leave the European Union. That was not what it was about. It was never about that. It was about what the powers of the government were and what the powers of Parliament were. And it's a very easy situation. The government cannot change the law unless Parliament has given it power to. But it can make and unmake treaties. And the question was whether, by giving the notice to leave the European Union, the government would be bringing about automatically a change in the law, which they're not allowed to do. Perfectly straightforward constitutional question. And by the time it got to us in the Supreme Court, I think people did understand much more what the question was. And that was partly because it was being broadcast. And loads of people, millions of people watched 4 days of legal argument, really boring, tedious legal argument in the Supreme Court. And I think it then got home to people that the case was about something else. So it's a great shame that the general public were being given the impression that the case was about a different issue from what it really was about. And that is a shame. But I think it would have been easy to stand up to it. I think the Lord Chancellor of the day could and should have got up and said, We have a free press in this country. You are entitled to write what you like and to publish photographs if you like. But it is my duty, as the member of the government who's sworn to uphold the rule of law and the independence of the judiciary, to tell you that you're wrong. These are not enemies of the people. These are serious, independent judges who are making a decision on a legal question according to their judicial oaths, according to law, in other words. And by the time it got to us, of course, basically that is what happened. There weren't the same headlines, and the government did declare that it supported our right to decide as we had done. So the overall story did not have an unhappy ending.
It's interesting that you regard it as a shame that that's how it was filtered, and the lens through which the newspapers in question decided to talk about it. But after the government's appeal failed, the Bar Council, I understand, launched a scheme to teach secondary school children about the importance of the impartiality of the judiciary. And that does seem to suggest that this is seen as something that really did do some pretty profound damage in terms of people's understanding of the separation of powers and the impartiality of the judiciary.
I'm not sure that it did damage. I suspect that there was widespread lack of knowledge before then. One of the things that I really wish we could do, which is done in other countries, is to teach children in school the rudiments of our constitution. You know, what the institutions are, what they do, what the relationship between them is, and that would include the rule of law and the independence of the judiciary, but it would include a lot of other stuff as well, but in nice, simple terms that children can understand. And I think if that happened in schools, there wouldn't be the same need to educate people long after they should have been educated. So, and another of my regrets, my hobby horses, is that it's a great shame that history courses don't teach the history of the 17th century.
And why is that in particular so important? Explain to us.
Well, the 17th century is when we had our revolution. We had two revolutions. One of them involved actually executing our king and replacing him. The other one involved replacing the king. And in the course of the 17th century and the various battles between the courts, Parliament and the king, our present constitution was established with the supremacy of Parliament and the rule of law. And it's a very exciting story as well. So it seems to me to be a great shame that it isn't more frequently told in schools.
Let me ask you another question about schools. This is a question that's come in from Metka Potocznik. I hope I'm pronouncing your name correctly. I probably am not. I apologize. In light of Brexit, students' number one question is, why do you make me study EU law now? What, in your view, is the most convincing reason for students to continue studying EU law, if at all? Well, I'm not the right person to ask that. For a start, I'm not a university teacher, nor am I the person who dictates for professional reasons what the university courses should contain in order to qualify them for the first part of professional qualifications. We do, of course, still have a great deal of EU law, which is now part of UK law. Some of it is UK law, which was done because of EU law, but independently of it, and some of it is directly derived from EU law. So I think understanding large swathes of law, which are derived from EU law, is going to be important for a very long time. And I suspect that Dame Elizabeth Gloster will have views on that as well, because as a commercial judge, she will know how often areas of law which are derived from EU law come up, and in which the judgments of the European Court of Justice may still be not any longer binding, but of some relevance. I'll put it no higher than that. Just before we bring Liz in on this conversation, I just want to go back to the impartiality of the judiciary in the context of the United States. You had a conversation with Ruth Bader Ginsburg on the BBC when you were guest editing the Today programme, and I had the privilege of interviewing her just last year when she won $1 million for the Berggruen Prize, and at the time the impeachment was imminent, and she talked very clearly about the kinds of comments that senators were making before the impeachment hearings were starting. I wonder if you'll reflect for us on the shift that has clearly taken place in her lifetime in the United States. The Supreme Court justices in the US have always been political appointees, but the contrast between her appointment, which was confirmed by 96-1, and the previous two justices on the Supreme Court, which were much, much closer, 55-43 in one case. I just wonder how you would reflect on what that does to the way in which justice works in practical terms when you view it as an observer and how you compare it to the UK.
Well, I think my comment would be that I would very much rather have the system of judicial appointments that we have in this country than the system of judicial appointments that they have in the United States. Because ours is almost completely devoid of any political involvement at all. It's done by independent, merit-based appointing commissions, and that has had various advantages. For a start, it has distanced it from any possibility of political influence, but it has also greatly increased the diversity of our judiciary. Hasn't done it enough yet. There's plenty of distance still to go, but it has made a difference. So I think my main reflection is I am so glad that we have the system that we have here rather than the one they have in the United States. But I could comment a bit more than that, I think, which is that even though the justices in the Supreme Court are political appointments in the sense that they are appointed by they're nominated by a president of a particular political persuasion and then confirmed by the Senate, which may or may not be dominated by the same party. But there's something about becoming a judge. You know, you assume the office, and the office has a power greater than those who appointed you. And we've seen several examples in the US of judges who were appointed by conservative presidents who've actually turned out to be not conservative at all in their approach to certain sorts of question. So, and you can also overestimate the extent to which politics, in a party political sense, enters into anything that judges do. Most of our work has got nothing to do with political questions. So I wouldn't want to be too depressed about the US system, not too depressed, but I'm still very glad we've got ours rather than theirs.
Just before we bring Liz in, just one more question from the audience. I'm sure we'll have time for some others too. What's your view on the government's establishment of an independent review of judicial review? Could statutory codification of the grounds of judicial review potentially threaten the role of the common law courts?
Well, I'm going to play us straight back to that because they're asking for evidence at the moment. They've got a consultation document. The Supreme Court is obviously going to be responding to that document. I will respond to that document, and I'm sure that I won't want to say anything that contradicts what the Supreme Court says. So I am keeping my powder dry for the time being.
Let's bring Liz in. Dame Elizabeth, I wonder if you will join us. There you are. Hello. Hi. Let's just start by getting you to reflect and respond a little bit on some of the questions that that Lady Hale has been answering. What do you make of what you've been hearing?
Well, it's rather boring, but I think we're slightly singing off the same hymn sheet, which may be a first, but there you are. In particular, I agree with her that the media's write-up of the Court of Appeal Brexit decision and the appellation of enemies of the people was just appalling. And but it showed a lack of understanding, or a fake lack of understanding, I think, of the media, or maybe just a wish to present that view to its readers. Anyway, I better not say anything more about the publication. But I mean, it was so ill-informed. And I think luckily when it got to the Supreme Court, David Neuberger, as then president of the court, made it absolutely clear what the role of the Supreme Court was in the decision. And there wasn't any problem about it.
I wonder if I can get both of you to talk about the starting point of this conversation, the reputation of London as and the standing of London as a place of international dispute resolution, because there is a question here from someone in the audience whether there is any real threat to that standing. What do you think, Liz?
Well, I think I'm very interested in the relationship between business and the rule of law. And that's always been my particular focus. And I think the background to that is, and I think I'm slightly upping the figures that were mentioned in the introduction, that according to a 2020 KPMG report commissioned by the Law Society, the UK legal sector contributes approximately £60 billion to the economy. That's English law, English legal services, and its institutions are therefore significant contributors to the UK's GDP. They're substantial job creators and underpin the sizable export of UK legal know-how and international influence. And it's English law, the English rule of law, are recognised as key factors in promoting that infrastructure, commercial infrastructure, supporting the sustainability of our banking and capital and insurance markets. And it underpins, and this is the real point from a business perspective about the rule of law, is that it underpins the attraction of the UK as a destination for inward investment. And so it seems to me that there is a real asset there which needs to be preserved. And the fact that England, the UK, has a widespread international reputation as a disputes resolution hub. And I'm not just talking about the English courts, I'm also talking about arbitration, mediation, and other forms of dispute resolution. We have that international reputation, but we cannot be complacent. We have to take appropriate steps to preserve it, not just to preserve the jobs of lawyers and arbitrators and commercial court judges and Supreme Court judges and Court of Appeal judges, but in order to preserve the input that has on inward investment and markets in the UK generally. And what I think is interesting about the title of your webinar today is that we are approaching this question at a time when other countries are recognizing the economic value of setting themselves up or competing as international dispute resolution hubs. And I'm not just talking about countries in the EU who are, of course, very keen to eat our lunch now that we're leaving the EU, but also centres in the Middle East, Singapore, and other centres around the world. And the other thing that I think is important is that what is needed, and this is my view, and I would say this, wouldn't I, as coordinator of Legal UK, what is my view is that this has got to be supported by serious government engagement and government support, recognizing that it's not supporting fat cat lawyers, but it's supporting the infrastructure, the capital markets, the British economy. Now, that all sounds rather grandiose, but what is interesting, and I draw your attention to it, is that an all-party group of MPs have recognised this need, and they are just about, on I think the 21st of October, to produce a report which has been sponsored by CIARB, which, and I quote, is entitled "Securing the UK's Position as a Global Disputes Hub, Best Practice Lessons between Singapore and the UK." So these chaps have gone over to Singapore, learnt some lessons, come back, and one of their recommendations, and this is going back to my point about proactive support from government, is that the all-party report actually suggests that there should be more government engagement, more government support along the lines of the huge support that Singapore has pumped in to its legal infrastructure, both in mediation cases, commercial cases, and dispute resolution. So that, I think, is a very optimistic step forward, that is the recommendation, or appears to be the recommendation, from what one can see about the blurb about this. So to come back to the other topic in your webinar flyer, the rule of law. Yes, the rule of law, I think, is critically important to the business world's perception of us as a dispute resolution hub, an international dispute resolution hub. And I, like lots of other people, are concerned that the value of that, the value of the fact that the UK respects international treaties, or has done pretty much to date, although not always. The fact of the importance of the rule of law to that whole economic base is recognised. Have I answered your question? I'm not sure I have.
You have, but I wonder if I can get Lady Hale to reflect on the point that you're making when you talk about the all-party, the recommendations that are being made. You seem to be suggesting, you use the word complacency, and you worry that there isn't enough government support behind the points that you're making. I just wonder whether in that context, Lady Hale, you will just reflect for us on the importance of this engagement between government and the reputation of the country, and what are the things that underpin the reputation of this country going forward, you know, a post-Brexit scenario.
Well, I really don't have anything much to add to what Dame Elizabeth has said, because she's a much greater expert in this area than I could ever be. I think it's very important that the government acknowledges that a strong and independent legal profession and judiciary, and properly resourced and equipped courts, how important they are to the whole British economy, because there is no doubt that they are important to the whole British economy. Government acknowledging that, among all the many other things they have to worry about at the moment, would no doubt be a great help. I don't know that there's a huge threat other than through the development of other places wanting to take over. I think there is something of a threat, but for as long as English law is chosen as the bedrock of many, many commercial transactions and investments, then the impetus to use English courts in order to resolve disputes is greater. My daughter is an investment banker, she was, and she used to work in emerging markets. And she said the one thing that they always did was to do their bond market origination using English law and English documentation, because that reassured investors that those emerging markets, they could safely invest in those emerging markets because the disputes would be properly resolved by an independent judiciary in accordance with English law. So it benefited both the investors and the sovereigns in whom they were investing, where there might have been doubt about whether the rule of law really operated there. And I thought that was a very good illustration of how important it is for us to continue to perform that role.
I wonder, Liz, whether you'll take this question. This is from Stephen Wright. Are there risks, reputational or otherwise, in the English court spending so much time on disputes between, and these are all his words, usually unsavory Russian oligarchs?
Well, I hope that's not being focused on me just because I did the Berezovsky case all those many years ago. I wouldn't dream of commenting on the adjectives that have been used, but what is important about the English Commercial Court, and indeed English arbitration or English seated arbitration, which is supervised by the English courts, is that players, whatever bad deal or bad experience they've had commercially, know that when they come to the English Commercial Court or the Chancery Division or wherever it is, they are going to get a fair trial, even if in their own country they would probably be locked up in jail, even for trying to bring the action or defend the action. So on the contrary, I don't think that there is any reputational risk to the English legal system, by reason of the fact that a lot of cases are dealing with disputes, commercial disputes between businessmen, however you want to describe them, and who knows till the cases come to an end, whether the bad guy is the bank or the bad guy is the former director of the bank who's accused of taking money. One just doesn't know till the end of the case. And I think it says a lot for the integrity of our system and the fact that foreign businessmen, whatever their problems in their own country or in the country they've been doing business in, are convinced and certain that they will get a fair deal out of the English courts. And that was, I have no doubt that that is why the English Commercial Court gets a lot of business and a lot of good dispute resolution business, as indeed as a lot of English seated arbitrations. So no is the answer, I think, to the question.
This is one for you, Lady Hale, from Alex White, senior counsel and former politician. He says he was struck by your comment about the value of unpredictability on the part of the judiciary. In Ireland, people, especially politicians, complain all the time about this and want the judges to be more predictable. Personal injuries awards, prison sentences, etc. Do they have a point, or would you say a little more about that for us?
Yes, of course I would, because I was talking about predictability in a very specific sense. Because if the law is clear, then the answer to any given set of facts ought to be equally clear and predictable. And it's very important that it is. So he's right, it's important that it's predictable. But there are a lot of cases, and they're the ones that tend to come before the higher courts, where the law is not clear. And it could be decided in either direction. The Supreme Court only deals with arguable points of law of general public importance. And those are the ones on which you don't want people to be so pigeonholed as that person's a conservative, that person's a liberal, that person's for a certain sort of thing, that person's for another sort of thing. You want people to make up their mind in accordance with the law and the arguments and the evidence. That's the point I was making. And that means that you can't just look at Hale, for example, and say, oh, well, she's always going to find for the women, because she isn't. That's the point I'm making.
In the last few minutes that we have left, I wonder if I can get both of you to perhaps reflect with each other on a big question that has come up in several questions, and I'm just going to read two of them because they kind of encapsulate them pretty well. So Alfie Darling is asking, are democracy and the rule of law entirely compatible, or must one outweigh the other? And in comparison with other democratic countries, how efficient is the UK in upholding the rule of law on a day-to-day basis? Lady Hale, let's start with you.
Well, I would say that the rule of law is an essential part of democracy. It works like this. Parliament makes the laws. Parliament is democratically elected. Well, the dominant bit of Parliament is democratically elected. The judge's job is to apply the laws which Parliament has made. What we do is in service of Parliament. Sometimes against the government, as has been seen. And so we are there to enforce and uphold the laws that Parliament has made. There are areas of the law which are made by the judges because Parliament has not yet dealt with them. But if Parliament doesn't like the decisions of a court on a question of law, Parliament can always change it. Just occasionally it does. Most of the time it doesn't care enough to do so, but it always can. So yes, of course they're compatible. And in fact, you can't have a proper democracy without the rule of law.
And perhaps, Liz, when we talk about other democratic countries, how efficient is this country in upholding the rule of law on a day-to-day basis? Because clearly the suggestion is that people take it for granted that we are.
Well, I would say this again, wouldn't I? Of course, I think this country, and my experience in the judiciary demonstrates it, that it is absolutely meticulous about upholding the rule of law, whatever sort of dispute there is. And if there is any problem about that, the upper court or the appeal court will come in to fix the problem and put it right. And can I give an example of that? I think one of the last cases which I did in the Court of Appeal was a dispute between effectively Russia as bondholder and I think the Ukraine as borrower under the bonds or issuer of the bonds. And there was the English Court of Appeal applying the rule of law as to quite complex questions about what were defences that could be raised of duress in relation to bonds that were repayable effectively on demand. And I'm not sure whether it's going to the Supreme Court, Brenda. I don't think it is. I'm not sure. Anyway,
I haven't checked. Sorry. Yes.
But I mean, that was a classic example of the Court of Appeal being meticulous in applying to what could have been regarded as outside our remit altogether, because it was dealing with obligations between states, but commercial obligations between states. So we thought that was fine. It wasn't caught by any sovereign immunity problem. But, you know, there we were applying in what others might regard as a political situation. The defense being, oh, well, you had your tanks on our lawn sort of thing. There was the court simply applying the rule of law. Does the defense of duress run in these circumstances? So I would say, yes, we're pretty good at doing that, of applying it.
Just to finally close the webinar this afternoon, I wonder, from what you're both saying, you're obviously very optimistic about the strength of the rule of law, its rootedness as we go forward, and I just wonder whether you are optimistic consistently, or whether you feel that there are bumps along the road that are going to happen because we know that there is overwhelmingly uncertainty ahead for all of us, not least because of the current public health crisis we find ourselves in, but also because of the uncertainty around the trade deals that we may or may not be able to make. So in that context, how consistently are you both optimistic?
You go, Brenda, you go.
Really? Really? Well, I think I'm one of life's cockeyed optimists and always have been. And so I'm sure you're right that there will be bumps along the way. There are bound to be. But I would draw a distinction, as I did earlier, between the substantive bumps and the actual bedrock constitutional bumps. And I foresee there will be substantive bumps, and there will be actual commercial bumps, but I'm hoping and praying that the bedrock constitutional bumps are pretty easy to get over.
Liz?
I'm pretty optimistic too. I just hope there's a recognition with some of our foreign colleagues in EU states that the mutual recognition of judgments, the mutual enforcement of judgments would be a good thing for both of us, not just for the UK. If I'm allowed to make that comment and it's not political, I think it would be a good thing, although I can argue the other way, of course. But I think we do need a bit of mutual recognition and enforcement of judgments. That might be a good thing, which would be my question mark, I think.
I would agree with that. That is the point that we have been making right from the word go. I think the judiciary have been making to the government that this is an absolute priority and they should try and find a way of sorting it out. And it applies throughout, not just in commercial disputes, it applies in all sorts of disputes, including family disputes. And yes, right. Indeed, it needs to be sorted out.
And so we have quite neatly come full circle. My thanks to all the partners involved in today's webinar, and of course to Elizabeth Gloster and to Baroness Hale. Thank you both very much indeed, and thank you all for being a part of this conversation today. Thanks for joining us.
Thank you.
Thank you.